The Supreme Court is siding with South Carolina and will allow the state to block Medicaid funding from Planned Parenthood. It's a case that has implications well beyond the Palmetto State and could mean changes to some women's health care.
Chief Legal Analyst Khalif Rhodes joining us this morning. Khalif, always a pleasure to have you in here. Are you surprised that there was this 6-3 decision, quite a dissent from some of the justices?
Surprised, yes and no. Not surprised by much that I see from this Supreme Court and this rendition of it, I should say. But yes, surprised by Clarence Thomas's additional comments is what I would probably say that surprised me the most, and for different reasons. The dissent was expected. The party line approach was expected as well, but the dissent opens up the door for a number of things. I mean, and if you look at this case, how it even got here doesn't make sense to me, so that's something that I would first address. This wasn't even about like abortion. This was a non-abortion related case, but somehow we ended this argument and we got here now ultimately surrounding around abortion. But this was about contraceptive, about STD prevention, about cancer awareness, and we're talking about $90,000. We're not even talking about like their whole budget, but it is centered now around about abortion and about the funding for, or at least defunding and getting rid of completely Planned Parenthood. So this argument took a complete left, right, and middle turn all at one point. But the argument that Clarence Thomas made specifically about 1983 claims, and you're right to be able to bring a claim, because in addition to this Planned Parenthood argument, there was also an argument about folks bringing a claim against the state for their decision to pick and choose the doctor of their choice. That problem is what I think is probably going to be more overarching, because Thomas unpacked this argument that we shouldn't even bring these 1983 claims and really wants to have a discussion about that. We're talking about 150 years of precedent. We're talking about what they used for the civil rights movement to be able to bring like any of the legislation that was brought in the 50s, 60s, and 70s, and he's saying that maybe we're not even getting that right.
So bringing it back to the right that people have to pick and choose any willing and capable provider, that was kind of one of the main arguments that we heard. What was it, the Fourth Circuit Court of Appeals here? It was a Reagan-appointed judge who held up that, saying that that's what's at the heart of this case. It's not necessarily...
I agree with what the Fourth Circuit Court of Appeals judge would say, and I'll start with this. I know one time, and we have a lot of fun here, right? We laugh, we joke. Sometimes I get extremely emotional about these things and animated and passionate, and I try to be, because this is what we do, right? And I want people to understand, and I maybe talk fast sometimes, part of that being because I'm from the North, but the other part of it is because I want to get as much information in folks' ears as I can, as quick as I can in a short amount of time. But you should be concerned when I slow down, when I really start to like unpack and try to think about the arguments that I'm going to say. And this one troubles me. This 1983 argument is disturbing. All of the legislation that was passed in the 50s and the 60s with the erosion of the 1983, that will be problematic for generations to come. And so while Clarence Thomas threw that in there as a good add-on, that portion is scary. If you're saying that folks don't have a right to sue, that things should be argued on the state level and the federal government should step aside. We've tried that before. George Wallace, Alabama. I mean, if you know anything about history, you know that those type of things are problematic when you have to get the president to send the National Guard to usurp them from a governor that's blocking the entrance of African-American students on a campus because of hate. Yeah, that's a problem. And so now we're drifting back that way. And so I want to read this right here. There's pundits, that peddlers of negative politics that think anything goes. And I say to them tonight, there's not a liberal America, not a conservative America. There's the United States of America. There's not a black America and a white America and a Latino America and Asian America. There's the United States of America. These pundits like to slice and dice America into this country of red states and blue states, but we're all one America. 2004, Barack Obama. I remember listening to that speech thinking that we were coming closer as a country, less divided, less, opinionated, less closer to the 60s than I thought. And now it seems like somehow we went in reverse, and the things that he talked about that gave folks hope to support his campaign are now being used to fund and push hate on a higher level. George Wallace, while pushing hate, won 5 states when he ran for president. 5. Alabama, Mississippi, Arkansas, all supported that. I often think, are we getting closer to those times? And so this opinion, this dissent, I should say, from Clarence Thomas It's troubling. It's scary as a parent to have to think about, wow, your kids are going to grow up in a harder era than you did because of politicians and oftentimes judges that may not be attempting to hit the mark. And this is where I'm at with this morning. It's reading this opinion, reading this dissent from the 3 justices, but reading his concurring opinion, disturbed.
And Khalif, something else in that dissent that could be a red flag warning is part of the dissent said that this could leave low-income women without care. Should women be worried about certain services that could disappear?
They should, and then I'll echo what Connecticut's governor said. It won't happen here. Back to the argument about this divided country, that while states' rights have an opportunity to make this decision, so a woman that lives in South Carolina won't have access to the same type of care, the same type of justice that a woman in Connecticut would, just because we're the state she's decided to live. That's what we're saying now. That if the Supreme Court is now telling you that the states can make this decision, because now states' rights have won, and that's a big issue. This is not a new argument in this country. 1830s, 1860s, we fought a freaking civil war about this same issue, about states having the right to make a determination. Connecticut's governor came out right after this came out and said, you know what, thank you for your opinion, Supreme Court, but it won't happen in our state. So they can do that in South Carolina. They can cut funding as much as they want, but we'll make sure that women in our state have access to those types of rights. So to your question, should you be concerned as a woman? Well, if you live in a state that's making a decision for you, yeah, you should be concerned. But if you live in a state that's giving you access and opportunity to be able to make a decision on your own, then I don't think you should. But the overarching question is that how we should be living as a country that should have equal rights and you should have an opportunity to live where you want? I think that's the overarching question, and our Supreme Court, even today, will touch on those types of questions. Do we have an equal justice system, or do we have one that's individually divided among our states?
And I know we have similar language in the big beautiful bill about Medicaid going to Planned Parenthood. So these exact same types of arguments and conversations likely bleeding over here into our legislative branch as well. So we'll keep you on tap talking likely about this again should the big beautiful bill pass. Khalif, thank you very much.
Queen City News Plus. Just search Queen City News on your smart TV's app store.